Hey, welcome back to the No Say Project. I'm Mark doing a quick tutorial on legal reasoning, legal writing called the IRAC method. Yes, the IRAC.
Said IRAC.
And what that stands for is issue, rule, analysis, and conclusion. And if you're looking at court documents, and if you're looking at court opinions such as the Supreme Court, well, I'll be looking at today from the District Court for the Central District of California, a very prominent case involving the January 6th Select Committee investigating the January 6th attempted coup and attack on the United States Capitol. Now, what the IRAC really comes down to is a deductive syllogism. And contrary to what some of my critics have said, yes, you do use basic principles of logic in legal reasoning and in legal writing. So just as we'll see that the IRAC is followed here, what an IRAC is a syllogism. So going back to ancient Greece, of course, a syllogism is a kind of logical argument that applies deductive reasoning to arrive at a conclusion based on two propositions that are asserted or assumed to be true. And so what we see is your typical syllogism: all men are mortal, Socrates is a man, therefore Socrates is mortal. Now, that's three, and IRAC has four. So to make it a straight IRAC, we would have the first one would be the issue, and that would be the question that we want answered. So in all legal decisions, an answer is given to a particular question. So if you're doing an appeal, was I denied due process of law and a fair trial by not being able to confront the witnesses against me? Here, what we would do is the issue would be, is Socrates mortal? That would be our issue. Then our rule is all men are mortal. And then the analysis, where we're going to take the facts, Socrates is a man. And then when we're through that analysis, applying the law to the known facts, we come to the logical conclusion that Socrates is mortal. So it's no different with an IRAC. So again, that is the issue, which is the question of law. Then we have the rule, which is going to be the actual law. And then the analysis is when we apply the facts to that law. And then the conclusion is the logical conclusion of our analysis of the facts and the law. So to use a contemporary case, and I like the subject matter of this came out just a few days ago, a U.S. District Judge David Carter, and this is a picture of him here on Google, and this is the actual decision, and it's the District Court in the Central District of California. The parties are John Eastman, who's an attorney for the twice impeached disgraced former President Donald Trump. The defendants are Benny Thompson, who was the head of the Select Committee to investigate the January 6th attack on the U.S. Capitol. So going through this, let's see if we can see the IRAC here. We have the four parts. The background is going to be our issue, and we have the facts. The legal standard is the rule, and we have the analysis, which is here called a discussion. And then the conclusion is the disposition. These are the four parts of the IRAC. So I just want to go through the component parts here one at a time. So here, before we get to the background, the judge is going to lay out what the actual issue is. The parties disagree on whether the documents are privileged. There's 111 documents. The parties disagree on whether the documents are privileged or if they should be disclosed. Well, that's our issue. So the background are going to be the known and accepted facts of the particular case. And it is fairly extensive here. It goes on for quite a few pages. For our purposes, demonstration, I don't need to go through all the facts. The facts are in there, and whatever particular issue you have is going to be based on the facts that you know. So now we get to the legal standard. The legal standard is going to be the rule. So we have the issue. Does privilege apply, in this case, to these 111 documents? And then we had the legal standard, the rule. What is the law on privilege? And so the judge here lays out the issue of the privilege, who the burden is on, such as with all evidentiary privileges, the burden of proving that the attorney-client privilege applies rests not with the party contesting the privilege, but with the party asserting it. So basic principles of logic and reason, the one who asserts bears the burden of proof. And then it gives some of the details, some of the elements. So if you're doing another law, there'll be particular elements, that particular law, and that's going to be laid out, which is very important, where the judge doesn't do it necessarily here in the text. He's got footnotes. So if you look here, he's got footnotes 70 276, and we go down here, these are the citations. You got to make sure. Now, typically, the way I was taught, if you're doing an IRAC, you need in the legal standard part or in the rule, you need to have the proper citation there in the text. Here, the judge, I guess it's correct. It either way is probably correct. The way I learned how to do it, it's in the text. Doesn't matter. But you got to make sure that you're properly citing your sources and that your your rules or your court cases are all current. You have to make sure you're using current law. So this part is really important. And the judge obviously took care of that. You need to do that. Now that we got the rule out of the way, now we've got to get to our analysis. Now, the analysis is where we're taking these elements, of the rule, the law, and now we have to apply it to the facts. And that's going to be the discussion part. And that is usually the longest part of an IRAC, is going to be the analysis, which is going to be how do these facts, if at all, fit with all the elements of the particular rule or law in question. And this is really, really extensive here. So it goes on for quite a while. So here we can see conspiracy to defraud the United States, and they're quoting the current law, 18 USC section 371. That crime, and it breaks down what the law says and the elements that need to be satisfied. That crime requires that at least two people entered into an agreement to obstruct a lawful function of the government by deceitful or dishonest means, and 3, that a member of the conspiracy engaged in at least one overt act in furtherance of the agreement. And then they lay out the facts that support that. So here, for example, as part of the analysis, the court discussed above how the evidence shows that President Trump likely knew that the electoral count plan was illegal. And that, of course, is cited here. President Trump continuing to push that plan despite being aware of its illegality constituted obstruction by dishonest means under Section 371, applying facts to the law. Again, Dr. Eastman's view on the Electoral Count Act are not, as he argues, a good faith interpretation of the law. They are a partisan distortion of the democratic process. His plan was driven not by preserving the Constitution, but by winning the 2020 election. Dr. Eastman, these are the facts. Dr. Eastman acknowledged that he didn't think Kamala Harris should have that authority in 2024. He didn't think Al Gore should have had it in 2000. And he acknowledged that no small government conservative should think that that was the case. Dr. Eastman also understood the gravity of his plan for democracy. He acknowledged you would just have the same party win continuously if the vice president had the authority to just declare the winner of every state. So they're showing the law requires the dishonest motive, dishonest means, and then they show the facts that Dr. Eastman, they quote Dr. Eastman directly to show the dishonesty. So here we get to the disposition. And I recommend you read this. I'll have it linked in the description. Read the whole thing because, again, this is not an analysis of this particular case. This is just a tutorial on how to do an IRAC, which is what the Judge Carter did here. But definitely take the time to read. It is only 44 pages, and it's pretty interesting. It's a pretty thorough analysis. And now we get to the actual conclusion, which is just answering the question of whether the law of privilege applies here to these facts, to these 111 documents. So what the judge says here, with this limited mandate, the court finds the following 10 documents privileged, and then gives an example. The court orders Dr. Eastman to disclose the other 101 documents to the House Select Committee. So the judge determined that the privilege, the attorney-client privilege, did not apply here. What's really interesting how he does here, and which has been reported extensively, in denying the privilege because they committed crimes. So when a lawyer is engaged in the commission of a crime with the client, there is no privilege. And that's what the judge lays out here. Based on the evidence, the court finds it is more likely than not that President Trump and Dr. Eastman dishonestly conspired to obstruct the joint session of Congress on January 6th. So because they were engaged in the commission of a crime, the conspiracy to obstruct an official proceeding, there is no privilege. So that's here you've got a federal judge who's saying, and they got to coach, they have to use that language there. It is more likely than not that the former twice impeached, disgraced serial liar, the vile Donald Trump, and his attorney, Dr. Eastman, dishonestly conspired. He's saying more like the facts show that they committed a felony of a conspiracy to obstruct the joint session of Congress, which they admittedly did. So that is it in a nutshell. That's of the IRAC. Again, you got the issue, which is the question of law. You've got the rule, which is the current law in question. Then you have the analysis, where you have the facts applied to the law and its elements. Then you have the logical conclusion of the facts and the law, which is the answer to your issue. So here it is. Are these 111 documents subject to privilege, the attorney-client privilege, or not? And the answer here is the judge very clearly points out that 10 documents are, 101 are not. So that's it for IRAC and how to do an IRAC. If you have any questions or concerns, leave them in the description and I will get to them. As always, thanks for watching.
At IRAC,